This is Greg Lois. Thanks for joining me today. Today is April 7th, Monday, and this is a first for me. I'm doing this webinar on liens, credits, pensions, Medicare, Medicaid, and third-party credits. We're going to talk about liens, and there's 4 different types of liens that impact workers' compensation settlements or recoveries. We're going to talk about child support liens, attorney liens, state temporary disability liens, and also private plan liens. Actually, they're pretty much handled the same way. And then we're going to talk about health plan or ERISA liens. Those are public employer health plan liens. And then I'm going to talk about the good stuff, which is credits. And I'm also going to talk about pensions. Some types of public disability pensions we can actually get an offset rate for. Others, the pension gets the offset rate. And then I'm going to end talking today very succinctly about Medicaid and Medicare liens and what we have to do to take care of those. So that's the discussion today. And as I went through this topic to prepare for today, which is largely coming out of Chapter 6 of the handbook that I write for the Matthew Bender series, I thought to myself, hey, this is a very in-depth topic. And it's complicated, and I know people are not going to like this. It also involves a tiny bit of math, which I know we all went to law school to avoid doing. And so what I tried to do was reduce today's conversation to, hey, is this thing that's going to happen at the time of the resolution of our case, is it a lien? Is it a credit or an offset? So that's the first question I want to answer for you. Who decides it? Who has got the power over it? Who's responsible for making sure the lien or credit is applied correctly? And what are the typical disputes that we see that typically hold up the resolution of a case? I've prepared a handout today, which if you're attending this live, you're able to download now. One of the downloads today is some materials that I've prepared in advance. Another one just says notes. And if you go to that notes as I'm talking about this subject, I really made an effort to try to reduce or summarize the concepts I'm going to talk about today to make this as practical and applicable to your cases and the situations that you're in as I possibly could. So there should be some good takeaways. I mean, if you're paying attention and you're taking notes, that's great, but you might want to look at the notes that I've prepared for you. This webinar series, as you know, follows the practice guide that I write for LexisNexis and is published by Matthew Bender. Today, I want to talk about what's largely covered in Chapter 6, which are the things that impact us at the time of resolution of a case. What are those things? So let's talk about the first things that we're going to talk about as liens against us that we're going to have to reimburse. The first one is child support liens. Now, child support liens are very easy to deal with in New Jersey because New Jersey has adopted the Uniform Interstate Family Support Act, which means that the workers' compensation courts take on the obligation, the clerk of the court takes on the obligation to search for and match any outstanding child support liens to open workers' compensation cases. So as the case develops, if there is a match, the court's online docketing system will identify your case so you'll know, hey, there's a potential child support lien here that might complicate the settlement of this matter. And the reason it's going to complicate the settlement for this matter is because the judge when the case is resolved, is going to issue a second order. And that second order is going to be called an order for distribution to pay back or to garnish any award that's being made. So if there are child support arrears, the order for distribution is going to say, hey, you've got to satisfy all these arrears, and it's going to reduce the amount of money moving to the petitioner or the claimant. And then it's going to garnish the amount of the award that the petitioner gets going forward. And so this can really disrupt the settlement of these cases. And one of the reasons it disrupts it is because the memorandum or advice letter says that a petitioner owes more in child support arrearages than maybe they're going to get from the workers' compensation case. They'll get nothing. Every dollar except for $2,000, which they are allowed to keep, must go to satisfy the lien. So you can imagine scenarios where a resolution is reached and the petitioner maybe is going to settle their case for $30,000, and then it's discovered they have a $50,000 child support lien, which, by the way, happens. You can get huge child support liens. Well, they're not going to get that $30,000 now. In fact, they're only going to get $2,000. Their attorney will be paid, their doctors will be paid, any court costs will be paid, and then they will get $2,000, and the rest will go to the children. Now, honestly, it seems fair to me, but it can disrupt settlements because petitioners will say, well, what am I doing here? Why am I settling this case? And they will often challenge and say, well, that lien doesn't apply, and that can delay the resolution of a case. Now, the Uniform Child Support Act also establishes how much wage or income can be garnished from ongoing awards. And that's going to range from 50 to 65%, depending on the size of the arrears and the number of dependents. So I'm not going to go into the math on that, but it does have to be calculated. And that is something that would be resolved in the order for distribution at the closure of the case. Now, the next type of lien I want to talk about is attorney's fees. Currently, the attorney's fee that is awarded in a workers' compensation case is not to exceed 25%, but difficulties arise when the petitioner has been represented by maybe a successive group of attorneys. They had one attorney, they fired them, they went to another attorney, and those attorneys don't agree on what the split of fee is. Well, the judge of compensation can decide that. They can determine the fee awarded, again, can't exceed 25%, and then they can apportion that fee. The attorneys can fight this out, and if they're not happy with the judge's determination, the judge of compensation's determination, they can directly appeal that issue to the appellate division. The third type of lien that I want to talk about is temporary disability liens, state or private. Now, these generally occur in disputed cases, and the situation that typically happens is the petitioner goes and receives temporary disability, that runs out, then they file a workers' compensation case. That's kind of a bad situation for the petitioner. Another common situation is where the petitioner files a claim petition, the claim gets denied by the employer or carrier, and then they go and apply for state temporary disability benefits, which they can. There's an application that they can fill out. They could say, I was injured at work, and the workers' comp case is disputed. When that happens, a lien attaches to the workers' compensation case. Problem scenario is where they go and apply for state temporary disability benefits, and they have not filed a workers' compensation claim petition. In that instance, they may be saying on the application that they were not injured at work. And so in cases where they've done that, it's important that we go and get a copy of that, everything they filed with the state. That can be the subject of a significant dispute, of course. The application and the supporting medical documents should be obtained so that we can determine, hey, is this temporary disability lien really related to our workers' comp case? It can also sometimes provide a basis for us to challenge the workers' compensability of the matter in its entirety. Because remember, that state temporary disability application has to contain the application signed by the claimant about why they're allegedly disabled, and it has to contain a doctor's certification stating whether the condition is work-related or not. What if the doctors say the condition's not work-related in the state temporary disability application? You'd certainly want to know that if you are in a controverted or denied workers' compensation case that you are defending. So it's very important to get that information. All right, let's move on to our next category of liens, which is private medical carrier and public employer or employer-funded carrier. No carrier, public employer-funded health plans. So you'll hear the term ERISA or ERISA plan to describe those types of plans. I see these plans in employers with more than 5,000 employees and certainly in public employers. Also very common is fully insured plans, like the one we have here at LOIS Law Firm for my employees. We're not big enough to have a self-funded plan. Our plan has to be in compliance with both that federal ERISA law and state law. Now, interestingly, the ERISA law, the federal law, puts a lot of control in the hands of the employer, including things like that the injured worker will execute a subrogation agreement on behalf of the employer should they have a potential claim against any third-party tortfeasor. So not only does the ERISA plan have a claim against the employee themselves, right, maybe a contractual claim, but also that they can, on their own, stand in the shoes of that employee and subrogate. You'll see that those public plans or ERISA plans typically do contain a subrogation provision and a reimbursement provision. But you know what? So do private plans. So most health carrier plans retain the ability to come to the workers' compensation carrier and say, hey, I paid for something you should have paid for. you have to reimburse me now. Now, interestingly, that reimbursement right against the employee, right? Because if the employee gets a workers' compensation benefit and money is expended by the private carrier, the interesting moment there is that private carrier can intervene in the workers' compensation case. And these are typically resolved at the time of case resolution. But because the claim against the employee by the private health carrier is contractual, the petitioner faces the jeopardy of a reduced recovery if the lien cannot be satisfied. In other words, let's say the petitioner gets $100,000 in the workers' compensation case in terms of a Section 20 award or an order approving settlement in the value of $100,000. But the private health plan says, hey, guess what? I expended $100,000 that should have been paid for by the workers' compensation carrier. Well, the employee doesn't get the benefit of that and would perhaps have to disgorge that money to the private health carrier. And the petitioner does not have to be made whole. In other words, that's not considered a double recovery. So they could take the entire workers' compensation award. So it's really important that these types of liens get resolved, and all parties really have to make sure that that gets resolved. So that is not hanging over the petitioner after the workers' compensation case is settled or resolved. In a lot of instances, we see the workers' compensation carrier issue a hold harmless that says, hey, we've looked into this. We don't think there's been private medical use. The petitioner will also often execute an affidavit saying that. And we'll say, well, we're going to hold harmless. Should any bills come forward that should have been paid for by the workers' compensation carrier, we will hold the petitioner harmless and thereby take responsibility for those bills. Now, I also tell you that even when you execute those hold harmlesses, you still have the right to negotiate the amount of the reimbursement with either the ERISA or the private plan that is demanding reimbursement from you. So you can give up that right. All right, let's turn on to a more cheerful topic now, credits. And when I describe credits, I'm talking about, hey, money that we may not have to expend, and these things will typically emerge in the resolution of our case. So the first thing I'm going to talk about is third-party action liens and credits. And these are often called action over liens, a situation where the petitioner does bring a claim against an actual tortfeasor and recovers at law. Now, interestingly, the injured worker and any of their dependents can bring those claims against any actual tortfeasor. And we have a powerful right to reimbursement from the proceeds of any recovery they obtain. We can recover all benefits paid, less $750 in costs, and up to 1/3 in attorney's fees. So in other words, we get to recover everything that they've received, except for the cost of litigation, and the costs of filing or court costs can be limited to only $750. So that's very powerful. But I also want to point out that the statute, Section 40, says it's up to 1/3 in attorney's fees. Oftentimes, and particularly in big awards or settlements or judgments over $1 million, you'll see that the third-party attorney, the attorney representing the petitioner as a plaintiff in the civil action, will take far less than 1/3 of the total recovery. Well, guess what? That means that our recoveries actually could be greater than 66%. Because we get obviously the inverse of whatever the plaintiff's attorney charges as their fee or takes as their contingent fee. So this is a very powerful tool, Section 40. It's very flexible. And of course, we can negotiate or compromise the amount of our reimbursement. What's included? What are we allowed to recover? Well, all medical treatment we've provided, all wage replacement benefits, any dependency benefits, and any permanent residual disability benefits. So really anything we've paid. What's excluded are litigation costs of the respondent, such as defense counsel fees, those would be my fees. Funeral expenses, which under the statute are not considered a payment of compensation. Anything recovered in a loss of consortium claim is not considered lienable. Now, we have to be thoughtful about that. If the claimant, the plaintiff recovers $10 million and $9 million of it is apportioned as a loss of consortium award for the plaintiff's spouse, we're going to challenge that. That's obviously unreasonable. There's obviously some gamesmanship going on there. So we're going to look into what the actual terms of the settlement were, particularly where the plaintiff says, oh, well, a lot of my award, more than 10%, let's say, was for a per quad or loss of consortium claim. Typically, Section 20 settlements are not considered lienable unless you specifically reserve that right on the Section 20 settlement documents. And that's why we always want to put on our Section 20 settlement documents, respondent reserves our right to reimbursement under Section 40. Even if there is no case pending, I've put that on there. We also are not allowed to get a recovery or reimbursement from any first-party claims against their own first-party benefit. So things like life insurance that was paid for by the petitioner or plaintiff themselves, or things like uninsured or underinsured motorist protection on their own policy would not typically be recoverable against. Also, interestingly, public entities in New Jersey are excluded from being responsible for returning reimbursement to us from the proceeds of any civil action, which really means that the public entity gets the benefit or the offset and we don't. And the last category of third-party actions that we're not allowed to recover against is those against insolvency funds, like New Jersey PLEGA, which is an insolvency fund. So there are some instances where we're not going to be allowed to assert our lien. All right, let's move into pensions. New Jersey has a huge amount of public employment, and we need to be mindful about what of those types of pensions and pension recoveries do we get an offset for? So this could reduce our overall exposure. So under the pension statute, there's ordinary retirement. So we're not talking about that. That's just someone who, by virtue of their time served or their contributions, and usually it's more than 10 years in the public employees retirement system, is eligible for an ordinary retirement. So we're not talking about that. We're going to talk about two very specific types of retirement. The first one is an ordinary disability retirement. If the petitioner is approved for an ordinary disability retirement and receive a workers' compensation award, the workers' compensation award is reduced by dollar for dollar the amount of the retirement benefit that is directly related to the workers' compensation claim. So if the reason for their ordinary disability retirement is they injured their low back, okay, and the workers' comp case is they injured their low back, so we've got the same body part or system, our workers' compensation responsibility would be offset dollar for dollar based on that, and because otherwise it would be a double recovery to the petitioner. Now, sometimes the petitioner is entitled to a Social Security award as well for the exact same injury. The respondent in that opportunity will then have the opportunity there to say, well, I'll take the ordinary disability retirement offset or the Social Security offset, whichever one is more favorable to the respondent. So the ordinary disability retirement pension receipt, that's great for us, that's useful for us, and that helps us reduce our workers' compensation exposure. More problematic is the accidental disability retirement. An accidental disability retirement, the pension benefit is reduced from what the respondent is paying in the workers' compensation action. So what happens there, if it's an accidental injury disability retirement unrelated to the workers' compensation case, workers' compensation does not get the benefit of the offset rate. Only the accidental disability retirement pension plan does. So that's not good for us. And you get into the situation where the claimant would never want to settle their workers' compensation case, even if they were entitled to a total disability, because it might reduce their pension benefit down significantly. To get around this, in 2011, Chief Judge Calderoni created what's called a continuing medical order, which can be used where the petitioner is receiving an accidental pension, so that money would not be reduced. And in that continuing medical order, essentially, the respondent is saying, yeah, the claimant, the petitioner, is completely and totally disabled forever and should be entitled to medical for life. However, we're not going to pay them any money because they're going to get all their money from their accidental disability retirement, and that might be significantly more. And so for that reason, the only exposure that the respondent, workers' compensation carrier, or employer would have would be for continuing medical, and there would be no future exposure for permanent residual disability payments. All right, let's move into our last section that impacts us at the time of settlement or resolution of our workers' compensation case. And that's that we have to take into consideration any Medicare eligibility and any Medicare entitlement, okay? And has the claimant actually utilized any of those public benefits? So the first one is Medicaid. If the petitioner has entitlement to medical assistance under Medicaid any amount they pay that was paid for by Medicaid that's related to our workers' comp case, okay, so we're looking for the same body parts, same system, same injuries, should be properly paid for by the workers' compensation carrier. Now, there are contacts that you can make to determine this. I've had very poor experiences with working with these contacts. Health Management System is a private company which contracts to provide lien information. I've had real difficulty. They really won't communicate with us unless we get releases from the petitioner. Petitioner's counsel will typically pursue any information about or challenge to Medicaid liens. However, I've discovered that they are often very slow to respond and slow to pursue these. And so this can be problematic and can significantly slow down the resolution of a case while this is being resolved between the parties. Payments to resolve Medicaid liens are paid to the Treasurer State of New Jersey and are issued to the management system, health management system up in Boston. And that's one of the other confusions, that New Jersey is where the health management systems is located. That gives information about the liens, but when you actually have to reimburse them, we're going to reimburse them to an address up in Boston. I've also had clients ask me, well, what's the tax ID number? And I've never been able to determine the tax ID number of the state of New Jersey, which I know can also make the processing of these repayments especially problematic. Last concept, or last thing that complicates the resolution of our cases is Medicare liens and the future exposure that we might have for medical treatment. So very easy to resolve are conditional payments. Medicare will often make payments because, usually by accident, the petitioner is just used to presenting their Medicare card when they're getting medical care, and they do that, and the physician is billing Medicare for something that should have been billed to us. In general, we'll get a conditional payment letter from Medicare. It's relatively straightforward. We'll just match up, is this CPT code the same that matches to what we're actually defending in the workers' comp case? If so, it's probably something that it would be our exposure to reimburse. Of course, if it's unnecessary treatment, we could still challenge it. And of course, if it's completely unrelated treatment, I've seen conditional payment statements which include injuries or body parts or treatments that have nothing to do with the workers' compensation case. So as long as they're related, it'll be our responsibility. And typically I find that our clients are very happy to reimburse Medicare because Medicare is paying for treatment at a much reduced rate than we would be paying even through our PPOs and other negotiated or contractual rates. The bigger challenge is, what about Medicare's future exposure? In 42 USC 1395Y, which is the Medicare as secondary payer statute, is very specific that we cannot shift the burden for the petitioner's treatment to Medicare in the future. That is illegal. Medicare is supposed to be secondary and workers' compensation should be primary. So that future exposure for medical care, it is not laid out in the statute how we're to take care of that or comply with the statute. But what's emerged over the years has been generally the use of set-aside arrangements. And these are relatively straightforward, and I'm not going to spend much time talking about them today. But what I've discovered is opposing counsel and even judges have a lot of confusion about what is a review threshold versus responsibility to always consider Medicare's future interests. And I'll just say this. If the petitioner's on Medicare, it doesn't matter the size of the settlement. We, one, must always look into conditional payments. And two, if they're eligible for Medicare, we must always consider Medicare's future interest. Now, it's true that Medicare has said we will not review any of these set-aside proposals that you have to comply with your obligation to make sure that future exposure for medical does not shift to Medicare if they're under a certain threshold, and that review threshold is $25,000. Well, I can't tell you how many attorneys, adversaries, judges, everyone gets confused and goes, well, Greg, we're settling this case for $24,999. We don't have to consider Medicare. And I said, of course you do. Medicare's just not going to review it, okay? Now, that's a conversation that has to happen frequently. I've had really very obtuse counsel say things like, hey, instead of settling this in one case for $50,000, let's do two for $24,999, and then we don't have to worry about Medicare. I'm like, yes, you do. Your guy or your lady is Medicare entitled. So it doesn't matter what the number or the value is, and we just have to be prepared to educate everyone about that. All right. I hope that this was useful and helpful. And what I did think was useful and helpful as I prepared for today's presentation was the notes that I came up with. And those notes I've included to everyone who's attending today live, which is this summary chart that I've created. If you think about the 8 different types of either liens or offsets or credits that will impact the overall settlement of value or the judgment value of your workers' compensation case, well, you've got to take all of these things into consideration when you're valuing a case for exposure as an attorney or setting your reserves as a carrier or adjuster or claims professional. We must always think about these things, and I try to create a simple and easy to use chart or checklist that combines all of these topics together. I also want to identify which one's a lien and which one is a potential for a credit or offset, right? So let's be thoughtful about these opportunities that we have to reduce exposure by being mindful of these concepts. And a lot of these, as you look at them, these are other statutes. The child support statute, it's not found in the workers' compensation statute. The temporary disability law is a completely different law. It's not found in the workers' compensation statute. ERISA law, right? Private health plan laws and contractual indemnification. That's not in the workers' compensation statute. The retirement statutes are not in our statute, and obviously Medicare and Medicaid. So we're really talking about the broader constellation of laws and statutory framework that impact the valuation and exposure in our workers' comp cases. All right, I hope this was useful for everyone. Let's take a look and see if there are any questions. And I do think it looks like there might be one. Ron is telling me, hey, Greg, the attachment is chapter 16, not chapter 6. Thanks, Ron. I appreciate you for checking that out. I think in prior meetings, I might have shared the whole handbook or not, but I will certainly provide the handbook reference to anybody who's looking for it. All right. Tawanga says, thanks for this presentation. Hey, you're always very welcome. And I'm looking through, it looks like that's all my questions. All right. We will meet up next month for our next topic. Thank you, everyone, for joining. I hope everyone has a great rest of the week. And if you have any other questions I didn't get to, or you didn't feel comfortable with asking me the questions live, always feel free to email me questions. Have a great day, everybody. Bye.